The duty of the personal representative to file an inventory and serve it upon all of the interested parties of a probate estate. Hi, I'm Darren Findling of the Probate Pro, and we're going to cover a very particular aspect of the responsibilities and duties of a personal representative. I'm speaking about the duty to inventory. And what we're referring to is a requirement to identify the assets that the decedent owned at the time of death. So we're talking about a snapshot, not assets that are received post-death, but assets that exist as of the date of death. That's the purpose of the inventory. Upon the personal representative's appointment, within 91 days of that appointment, there's a requirement to prepare this inventory. Now, there's not a requirement to necessarily file it. You may have to only present it if you're in an informal administration. Present it for purposes of calculating the gross inventory fee that is paid to the probate court. In supervised or formal proceedings, you have to file the inventory. Nonetheless, under each circumstance, there's a requirement to notify the interested parties of or to provide service of the inventory so that they're aware of what the assets are as of the date of death. So this issue about itemizing and inventorying can cause quite a bit of confusion. Why? Well, there are some assets that the person who died may have owned, but may have owned jointly, or may have owned with a named beneficiary, or may have owned in their trust. These are not assets that are probate assets. These assets flow according to a different process. In a joint ownership, the joint survivor takes the property outside of probate. In a trust, the trust will administer the trust assets outside of probate. And in a situation in which there's a named beneficiary, like a life insurance policy or maybe a bank account, the beneficiary identified in that account agreement is the one who receives the assets outside of probate. These are non-probate assets and do not get reflected on the probate court inventory. In addition, there's some confusion about what you list and with which particularity. The statute, which is MCL 700.3706, provides that the personal representative shall prepare an inventory of the property owned by the decedent at the time of death, listing with reasonable detail. So that term reasonable detail is really subject to court interpretation. In some circumstances, very particular detail is required. All of the tools and the pieces of jewelry and the personal property. But in most estates, it is more generalized, those types of loose, tangible personal property. So if there's a lot of dispute or litigation involving the estate, the inventories tend to be much more particular. The reasonable detail, as reflected in the statute, requires a very specific itemization. In most estates in which the family is getting along pretty well, the detail is a little less formal than that. However, there's no one size fits all, so we leave that to you and your attorney to identify what the right level of description is that would satisfy the statutory requirement of reasonable detail. In addition, there's a requirement to identify the type and amount of encumbrance that may exist, as well as identifying the date of value as of the date of death, or the value as of the date of death, rather. So again, value with real estate, generally we use 2 times the state equalized value, or if the property is recently appraised or sold. But with other assets, it can be a little more complicated. You may have to get an actual valuation in the form of an appraisal. And again, in some estates in which the family is getting along better, people generally estimate the valuation rather than spending the money and having a formal appraisal done. Again, this is a circumstance that you want to be working with your lawyer to identify that level of detail that is required for purposes of valuation. Now also remember that the larger the inventory value, the more the gross inventory fee that's owed to the probate court is. So often we see people that are personal representatives not trying to inflate the value for good reason. Again, that inventory, after it's completed, it is a state court administrative order form, scale form, and when it's completed, it is either presented to the probate court or filed and then served upon the interested persons in the probate estate for them to become aware of the estate. Now, if later on it is determined that there are additional assets that are discovered later on, however, they relate to what was owned by the decedent as of the date of death, the statute requires the personal representative to amend the inventory. So again, the snapshot as of the date of death will change. Now, there's a difference between an inventory and an accounting. An inventory is the description of the starting point of assets that existed as of the date of death. The duty to account is generally a yearly rhythm from that inventory, identifying any income and expenses and the remaining assets that exist after each year of administration if the estate goes on for more than a year. If you've got questions about the inventory or any probate related issue, visit us at theprobatepro.com, or even better yet, call us at 833-PROBATE.